So, very good evening, all the participants. Today, let us try to understand some of the allied laws. So, let us start with LLP and see how much we can cover. So, LLP, Bare Act is before you, and I hope I have already shared this PPT with you. This PPT I have already shared.
Yes, sir.
So, these are the various sections. Just a minute. Right, now I think it's better. So, limited liability, address. Let us see some of the definitions. Address in relation to a partner of LLP means if an individual, his usual residential address, and if a body corporate, the address of its registered office. Right? So, first question, whether a body corporate can be a partner in an LLP?
Yes.
Yes. Okay. These are the various definitions: body corporate, company, corporation, so on, the body corporate, business, or chartered accountant. So, these are the various definitions. Just a minute. Now, let us see section number 3. So section 3 says limited liability partnership to be body corporate. So limited liability partnership is a body corporate formed and incorporated under this act and is a legal entity separate from that of its partners. A limited liability partnership, like companies, it shall have perpetual succession, and any change in partners of a LLP shall not affect the existence, rights, or liabilities of the LLP. Now, non-applicability of Indian Partnership Act. So it says, save as otherwise provided, the provisions of the Indian Partnership Act shall not apply to LLP. Now, partners. An individual or body corporate may be a partner in a LLP, provided that an individual shall not be capable of becoming a partner of LLP if unsound mind, undischarged insolvent, applied to be adjudicated as an insolvent and its application is pending. Minimum number 2. If at any time the number of partners of LLP is reduced below 2 and the limited liability partnership carries on business for more than 6 months, while the number is so reduced, suppose there are 2 partners, one partner dies or he resigns, and this business is carried on for more than 6 months, while the number is so reduced, the person who is the only partner of the LLP during the time that it so carries on business after those 6 months and has the knowledge of the fact that it is carrying on business with him alone shall be liable personally for the obligations of the LLP incurred during that period. So here there are 2 important things. It says if it is reduced below 2 and the business is carried on for more than 6 months while the number is so reduced. So there could be a situation where within 6 months they induct a new partner. But if no partner is inducted and it is carried on and he has knowledge of the fact that it is carrying on business with him alone, shall be liable personally for the obligations of the LLP incurred during that period. Maximum number of partners, any idea about maximum number of partners in an LLP? नरेंद्र जी
50, सर.
नहीं 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 50 नहीं, देयर इज नो लिमिट, ऐसा कोई लिमिट नहीं है, 50 तो है नहीं,
ओके, नो लिमिट सर. ओके.
50 का कोई लिमिट नहीं है, क्यों काजल जी?
So 50 is in sorry partnership form.
यहाँ पर कोई लिमिट नहीं है,
2 to यहाँ पे नहीं है सर.
वहां पर भी 100 है वैसे, वो भी कहाँ दिया हुआ है? कंपनीज एक्ट में दिया हुआ है.
यस सर, कंपनीज एक्ट.
हाँ, डेजिग्नेटेड पार्टनर्स. तब तक नरेंद्र जी देख लीजिए, दोनों चीज चेक कर लीजिए आप, है ना. Maximum number of partners in an LLP, I think there is no limit. And maximum number of partners in a partnership firm, I think it is 100. 50 nahi, mere hisab se. Designated partners. Every LLP shall have at least two designated partners who are individuals, and at least one of them shall be resident in India. ठीक है. Provided that in case of a limited liability partnership in which all the partners are bodies corporate, or in which one or more partners are individuals and bodies corporate, at least two individuals who are partners of such LLP or nominees of such body corporate shall act as designated partners. ठीक है. तो दो इंडिविजुअल तो होने ही है. ऐसा भी हो सकता है ना कि भाई सारे ही बॉडी कॉर्पोरेट्स हैं, तो उस केस में भी क्या होगा? At least two individuals who are partners of such LLP or nominees of such body corporate, they shall act as designated partners.
सही है सर, आपका जो व्यू था सही है सर. नो अपर लिमिट इन केस ऑफ मैक्सिमम नंबर ऑफ पार्टनर इन एलएलपी सर.
ठीक है. Thank you. Explanation. For the purpose of this section, the term resident in India means a person who has stayed in India for a period of not less than 120 days
80
during the
days.
financial year. ठीक है. तो रेजिडेंट की लिमिट कितनी है? 120 days. Subject to the provisions of subsection 1, if the incorporation document specifies who are to be designated partners, such persons shall be designated partners on incorporation. First of all, we'll have a look at the incorporation documents. And if the incorporation document specifies who are to be designated partners, such persons shall be designated partners on incorporation. Or states that each of the partners from time to time of LLP is to be designated partner. Every such partner shall be a designated partner. Any partner may become a designated partner by and in accordance with the LLP agreement, and a partner may cease to be a designated partner in accordance with LLP agreement. ठीक है. An individual shall not become a designated partner in an LLP unless he has given his prior consent to act as such to the LLP in such form and manner as may be prescribed. ठीक है. Every LLP shall file with the registrar the particulars of every individual who has given his consent to act as a designated partner in such form and manner as may be prescribed within 30 days of his appointment. An individual eligible to be a designated partner shall satisfy such conditions as requirements as may be prescribed. And every designated partner of LLP shall obtain a DPIN, designated partner identification number, from the central government. And the provisions of section 153 to 159 of the Companies Act shall apply mutatis mutandis for the said purpose. Now, liabilities of designated partners. Unless expressly provided otherwise in this act, a designated partner shall be responsible for the doing of all acts, matters and things as are required to be done by the LLP in respect of compliance of the provisions of this act, including filing of any document, return, statement and the like report pursuant to the provisions of this act and as may be specified in the LLP agreement, and liable to all penalties imposed on the LLP for any contravention of these provisions. Now, change in designated partners. LLP may appoint a designated partner within 30 days of a vacancy arising for any reason, and provisions of subsection 4 and subsection 5 of section 7 shall apply. Provided that if no designated partner is appointed, or if at any time there is only one designated partner, each partner shall be deemed to be a designated partner. ठीक है, ये भी important. Now, punishment for contraventions of section 7 and 9. If the LLP contravenes the provisions of subsection 1 of section 7, the LLP and every partner shall be liable to a penalty of 10,000 rupees, and in case of continuing contravention, with a further penalty of 100 rupees for each day after the first day during which such contravention continues, subject to a maximum of 1 lakh rupees for the LLP and 50,000 rupees for every partner of such LLP. So this is important. So we can remember this कि ये वाला आपको कम से कम पनिशमेंट वाला तो ध्यान में रखना है. एक और पॉइंट ध्यान में रखना है कि if there is only one designated partner or if no designated partner is appointed, then each partner shall be deemed to be a designated partner. If the LLP contravenes the provisions of subsection 4 of section 7, such LLP and its every designated partner shall be liable to a penalty of 5,000 rupees. ठीक है. सबसेक्शन 4 क्या बोलता है? सबसेक्शन 4 ऑफ सेक्शन 7. सबसेक्शन 4 है कि फाइलिंग ऑफ particulars of the designated partner within 30 days of his appointment. So if you don't file, then this is the penalty. 5,000 rupees or फिर 100 rupees for each day and 25,000 rupees for its every subject to maximum of 50,000 and 25,000 rupees for its every designated partner. उसके बाद में पनिशमेंट है फॉर कॉन्ट्रावेंशन ऑफ सबसेक्शन 5. तो सबसेक्शन 5 ऑफ सेक्शन 7. सबसेक्शन 5 क्या बोलता है? An individual eligible to be designated partner shall satisfy such conditions and requirements as may be prescribed. So if you appoint a person as a designated partner who does not satisfy the conditions as per the rules, then this is the penalty, 10,000 rupees. And in case of continuing contravention, further penalty of 100 rupees per day, subject to a maximum of 1 lakh rupees. ठीक है. तो कितने टाइप की पेनल्टी होगी इसमें? 3 तरह की. पहली पेनल्टी क्या है? ये पेनल्टी है 10,000 रुपीज, 100 रुपीज पर डे और मैक्सिमम हो गया आपका 1 लाख रुपीज और 50,000 हो गया फॉर ईच पार्टनर. ये कॉन्ट्रावेंशन है सबसेक्शन 1 का. तो सबसेक्शन 1 क्या बोलता है? सबसेक्शन 1 बोलता है कि एटलीस्ट 2 डेजिग्नेटेड पार्टनर्स एंड वन ऑफ whom शैल बी रेजिडेंट इन इंडिया. ठीक है. अगर इसका कॉन्ट्रावेंशन है तो ये पेनल्टी है आपकी 10,000 रुपीज, 100 रुपीज पर डे, 1 लाख और 50,000 फॉर पार्ट. ठीक. सबसेक्शन 4 का अगर कॉन्ट्रावेंशन है, सबसेक्शन 4 है यू हैव टू फाइल ए फॉर्म विद इन 30 डेज. उसका अगर कॉन्ट्रावेंशन है तो 5,000 रुपीज, 100 रुपीज पर डे, मैक्सिमम 50,000 एंड 25,000 फॉर एवरी डेजिग्नेटेड पार्टनर. ठीक है. और सबसेक्शन 5, if you appoint a partner who doesn't fulfill the conditions, then penalty of 10,000 rupees, 100 rupees per day, maximum 1 lakh और 50,000 rupees for every. ये कुछ पेनल्टीज है. सेक्शन 11 देख लेते हैं. इनकॉर्पोरेशन डॉक्यूमेंट. For a limited liability partnership to be incorporated, 2 or more persons associated for carrying on a lawful business with a view to profit, ठीक है, shall subscribe their names to an incorporation document. तो it has to be with a view to profit. ये भी important है. The incorporation document shall be filed in such manner and with such fees as may be prescribed with the registrar of the state in which the registered office of the LLP is to be situated. There shall be filed along with the incorporation document a statement in the prescribed form made by either an advocate or company secretary or chartered accountant or cost accountant who is engaged in the formation of LLP, and by anyone who subscribes his name to the incorporation document, that all the requirements of this act and the rules made thereunder have been complied with in respect of incorporation and matters precedent and incidental thereto. तो कौन साइन कर सकता है? चारों में से कोई भी, CA, CS, ICWA या फिर एडवोकेट, और जो भी सब्सक्राइबर है वो भी. The incorporation document shall be in a form as may be prescribed, state the name of the LLP, state the proposed business of the LLP, state the address of the registered office of the LLP, state the name and address of each of the persons who are to be partners of the LLP on incorporation, state the name and address of the persons who are to be designated partners of the LLP on incorporation, contain such other information concerning the proposed limited liability partnership as may be prescribed. And if a person makes a statement which he knows to be false or does not believe to be true, shall be punishable with imprisonment for a term which may extend to 2 years and with fine which shall not be less than 10,000 rupees but which may extend to 5 lakh rupees. Section 12. Incorporation by registration. So when all these requirements are complete, the registrar shall retain the incorporation document, and unless the requirements imposed by clause A. What are the requirements of clause A? Clause A बोलता है it shall be filed in such manner and such fees. ठीक है. तो subject to filing of the documents, he shall within a period of 14 days register the incorporation document and give a certificate that LLP is incorporated by the name specified therein. The registrar may accept the statement delivered under clause C of subsection 1 of section 11 as sufficient evidence that the requirements imposed by clause A of that subsection have been complied with. Now, registered office of LLP and change therein. ये भी important है कि all the communications shall be at the registered office. ये इसके बारे में पूछ लेता है वेबर. A limited liability partnership may change the place of its registered office and file the notice of such change with the registrar in such form and manner and subject to such conditions as may be prescribed. So we have to see the rules. And if any default is made, then LLP and its every partner shall be liable to a penalty of 500 rupees for each day during which the default continues, subject to a maximum of 50,000 rupees for the LLP and its every partner. Effect of registration. Name shall have either words LLP or limited liability partnership. Reservation of name. A person may apply in such form and manner and accompanied with such fees as may be prescribed for the reservation of a name. So this may be reserved for a period of 3 months. Rectification of name. Notwithstanding anything contained in section 15 or 16, if through inadvertence or otherwise LLP on its first registration or its registration by a new name is registered by a name which is identical with or too nearly resembles to that of any other LLP or a company or a registered trademark of a proprietor under the Trademarks Act, as is likely to be mistaken for it, then on an application of such LLP or proprietor referred to in clause A and B respectively or a company, the central government may direct that such LLP to change its name or new name within a period of 3 months from the date of issue of such direction, provided that an application of the proprietor of the registered trademark shall be maintainable within a period of 3 years from the date of incorporation or registration or change of name of the LLP under this Act. So if you want to contest, then you have to move this application within a period of 3 years from the date of incorporation or registration or change of name of the LLP. So if you change your name, then you have to inform within a period of 15 days of such change. And if there is a default, central government shall allot a new name to the LLP. Change of registered name. So change is also a penalty for improper use of the words LLP or LLP. If any person or persons carry on business under any name or title of which the words limited liability partnership or LLP or any contraction or imitation thereof is or are the last word or words, that person or each of those persons shall, unless duly incorporated as LLP, be punishable with fine which shall not be less than 50,000 rupees but which may extend to 5 lakh rupees. Publication of name. Best. Every LLP shall ensure that its invoices, official correspondence and publications bear the following: name and address of its registered office and registration number of the LLP and a statement that it is registered with limited liability. If the limited liability partnership contravenes, then fine penalty of 10,000 rupees. Partners. Eligibility to be partners. On the incorporation of a limited liability partnership, the persons who subscribed their names to the incorporation document shall be its partners, and any other person may become a partner of the LLP by and in accordance with the LLP agreement. Relationships of partners. So mutual, this is also important. save as otherwise provided by this act. The mutual rights and duties of the partners of LLP and the mutual rights and duties of LLP and its partners shall be governed by the LLP agreement between the partners or between the LLP and its partners. The LLP agreement and its changes, if any, made therein shall be filed with the registrar in such form, manner, and accompanied with such fees as may be prescribed. This is very important. In the absence of agreement to any matter, the mutual rights and duties of the partners and the mutual rights and duties of the LLP and the partners shall be determined by the provisions relating to that matter as are set out in the first schedule. A person may cease to be a partner in case of death, declaration of unsound mind, and his application has to be adjudged as insolvent. This is also important कि to what extent this person is liable. Where a person has ceased to be a partner of LLP, hereinafter referred to as former partner, the former partner is to be regarded in relation to any person dealing with the LLP as still being a partner of the LLP unless the person has noticed that the former partner has ceased to be a partner of the LLP or notice that former partner has ceased to be a partner of the LLP has been delivered to the registrar. ठीक है? Either that person should have the notice or the notice should have been delivered to the registrar. The cessation of a partner from the LLP does not by itself discharge the partner from any obligations to the LLP or to the other partners or to any other person which he incurred while being a partner. Where partner of LLP ceases to be a partner unless otherwise provided in the LLP agreement, the former partner or a person entitled to his share in consequence of the death or insolvency of the former partner shall be entitled to receive from the LLP an amount capital contribution, right and profits after deduction of accumulated losses. A former partner or a person entitled to his share in consequence of the death or insolvency shall not have any right to interfere in the management of the LLP. Registration of change in partners. Every partner shall inform the LLP of any change in his name or address within a period of 15 days of such change. Okay? LLP shall, where a person becomes or ceases to be a partner, file a notice with the registrar within 30 days from the date he becomes or ceases to be a partner. ठीक है? So 15 days period किसके लिए है? For partner information to the LLP, and LLP will inform the registrar within 30 days. Where there is any change, the name or address of a partner, file a notice with the registrar within 30 days of such change. ठीक? Now partners as agent. They ask a question usually on this section. Every partner of LLP is for the purposes of the business of the LLP, the agent of the LLP, but not of other partners. This not of other partners is important because in case of partnership, the every partner is a partner of the partnership firm and of other partners also, but not in case of LLP. Here, every partner is for the purpose of the business of the LLP, the agent of the LLP, but not of other partners. ये इंपॉर्टेंट है, मैं पूछ लेता हूँ क्वेश्चन. Extent of liability. A limited liability partnership is not bound by anything done by a partner in dealing with a person if the partner in fact has no authority to act for the LLP in doing a particular act, and the person knows that he has no authority or does not know or believe him to be a partner of the LLP. The partnership is liable If a partner of LLP is liable to any person as a result of a wrongful act or omission on his part in the course of the business of the LLP or with its authority. An obligation of the LLP, whether arising in contract or otherwise, shall be solely the obligation of the LLP. The liabilities of the LLP shall be met out of the property of the LLP. Okay. The extent of liability is also important. Extent of liability of partner. A partner is not personally liable directly or indirectly for an obligation referred to in subsection 3 of section 27 solely by reason of being a partner of the LLP. The provisions of subsection 3 of section 27 and subsection 1 of this section shall not affect the personal liability of a partner for his own wrongful act or omission, but a partner shall not be personally liable for the wrongful act or omission of any other partner of the LLP. This is also important. Now, holding out. Any person who by words written or by conduct represents himself or knowingly permits himself to be represented to be a partner in an LLP is liable to any person who has, on the faith of any such representation, given credit to the LLP, whether the person representing himself or represented to be a partner does or does not know that the representation has reached the person so giving credit. Provided that where any credit is received by the LLP as a result of such representation, the LLP shall, without prejudice to the liability of the person so representing himself or represented to be a partner, be liable to the extent of credit received by it or any financial benefit derived there. Now, where after a partner's death, the business is continued in the same LLP name, the continued use of that name or of the deceased partner's name as a part thereof shall not of itself make his legal representative or his estate liable for any act of the LLP done after his death. Okay. Sometimes you use a personal name. Okay. R.K. Gupta LLP. And suppose R.K. Gupta dies, then and the business is continued. So continued name does not of itself does not make his legal representative of R.K. Gupta or his estate liable. This is the meaning. Unlimited liability in case of fraud. In the event of an act carried out by LLP or any of its partners with intent to defraud creditors of the LLP or any other person or for any fraudulent purpose, then the liability shall be unlimited. Provided that in case any such act is carried out by a partner, the LLP is liable to the same extent as the partner unless it is established by the LLP that such act was without the knowledge or authority of the LLP. Now, who is liable? Any person who carries on fraud shall be punishable with imprisonment for a term which may extend to 5 years and with fine which shall not be less than 50,000 rupees but which may extend to 5 lakh rupees. Where LLP or any partner or designated partner or employee of such LLP has conducted the affairs of the LLP in a fraudulent manner, then without prejudice to any criminal proceedings, the LLP and every partner or employee shall be liable to pay compensation to any person who has suffered any loss or damage, provided that such LLP shall not be liable if any such partner or designated partner or employee has acted fraudulently without the knowledge of the LLP. Now, whistleblowing. The court or tribunal may reduce or waive any penalty leviable against any partner or employee if it is satisfied that he has provided useful information during investigation. Where any information given by a partner or employee leads to LLP or any partner or employee being convicted. No partner or employee of any LLP may be discharged, demoted, suspended, threatened, harassed against the terms and conditions of his LLP or employment merely because of his providing information. Form of contribution. A contribution of a partner may consist of tangible, movable, or immovable or intangible property or other benefit to the LLP, including money, promissory notes, other agreements to contribute cash or property, and contracts for services performed or to be performed. The monetary value of contribution of each partner shall be accounted for and disclosed in the accounts of the LLP in the manner as may be prescribed. Now, obligations to contribute. The obligation of a partner to contribute money or other property or other benefit or to perform services for LLP shall be as per the LLP agreement. A creditor of LLP which extends credit or otherwise acts in accordance with an obligation described in that agreement without notice of any compromise may enforce the original obligation against such partner. Maintenance of books. Double entry system. 6 months time. This is very important. They ask a question on this. Okay, what is the time period within which the statement of account and solvency is to be prepared? So every LLP shall, within a period of 6 months from the end of each financial year, prepare a statement of account and solvency for the said financial year as at the last date of the said financial year in such form and manner as may be prescribed. Every LLP shall file within the prescribed time the statement of account and solvency with the registrar every year in such form and manner. Okay? So within 6 months, they have to prepare and they have to file within the prescribed time. The accounts of the LLP shall be audited in accordance with such rules as may be prescribed. Just a minute. और देख लेते हैं कोई इंपॉर्टेंट बात है तो पेनल्टी हो गया अकाउंटिंग स्टैंडर्ड एनुअल रिटर्न. Annual return is to be filed within 60 days of the close of its financial year. तो एनुअल रिटर्न है और स्टेटमेंट ऑफ अकाउंट एंड सॉल्वेंसी. Compounding of offenses, enforcement of duty to make the returns, partners transferable intents, investigation of the affairs of LLP, application by partner, production of documents, seizure of documents, application for winding up, procedure for recovery, expenses of investigation, conversion from फॉर्म इनटू LLP. ये कन्वर्जन वाला थोड़ा सा देख लेते हैं. चैप्टर 10. दिस इज इंपॉर्टेंट. A firm may convert into LLP in accordance with the provisions of this chapter and the second schedule. ठीक है, तो कन्वर्जन वाला थोड़ा सा ध्यान से देख लेंगे. कुछ शेड्यूल्स हैं, शेड्यूल्स भी देख लेंगे अभी. Then conversion from private limited company into LLP. A private company may convert into LLP in accordance with the provisions. Then conversion from unlisted public company into LLP. An unlisted public company may convert into LLP in accordance with the provisions of this chapter and the fourth schedule. तो सेकंड शेड्यूल में कन्वर्जन है फ्रॉम फर्म टू LLP, थर्ड शेड्यूल में प्राइवेट कंपनी टू LLP और फोर्थ शेड्यूल में अनलिस्टेड पब्लिक कंपनी टू LLP. Foreign LLP. So for foreign LLP also they sometimes ask the questions. अब देख लीजिए, ये हो गया हमारा एक्ट. अब उसके बाद में शेड्यूल्स देख लेते हैं. 4 शेड्यूल है इसके, चारों शेड्यूल देख लेते हैं. फर्स्ट शेड्यूल में क्या बोलता है? म्यूचुअल राइट्स, प्रोविजंस रिगार्डिंग मैटर्स रिलेटिंग टू म्यूचुअल राइट्स एंड ड्यूटीज ऑफ पार्टनर्स. क्या क्या है वो तो पहले कहता है भाई, सबसे पहले तो आप LLP एग्रीमेंट देख लो. The mutual rights and duties of the partners and the mutual rights and duties of the LLP and its partners shall be determined subject to the terms of any LLP agreement or in the absence of any such agreement or any matter by the provisions in this schedule. ठीक है, तो पहले तो आप LLP एग्रीमेंट में देख लो. LLP एग्रीमेंट में नहीं लिखा तो यहां से देख लो क्या है. All the partners of LLP are entitled to share equally in the capital, profits and losses. The limited liability partnership shall indemnify each partner in respect of payments made and personal liabilities incurred by him in the ordinary and proper conduct of the business of the LLP, in or about anything necessarily done for the preservation of the business or property of the LLP. ठीक है. Every partner shall indemnify the LLP for any loss caused to it by his fraud in the conduct of the business of the LLP. Every partner may take part in the management of the LLP. No partner shall be entitled to remuneration. ये भी important है. No partner shall be entitled to remuneration for acting the business or management of the LLP. ठीक है. LLP agreement में लिखा है तो अलग बात है. No person may be introduced as a partner without the consent of all the existing partners. This is also important. है ना? So introduction of partner, consent of all the existing partners. Any matter or issue relating to the LLP shall be decided by a resolution passed by a majority in number of the partners, and for this purpose each partner shall have one vote. तो यहाँ शेयर कैपिटल वाला फंडा नहीं है. ऐसा भी हो सकता है ना, देयर मे नॉट बी एनी शेयर कैपिटल. However, no change may be made in the nature of business of the LLP without the consent of all the partners. इस पर कभी सवाल पूछ लेता है कि they want to change the nature of business of the LLP, तो whether consent of majority or 75% or all is required. तो यहाँ क्या है? It cannot be changed. No change may be made in the nature of business of the LLP without the consent of all the partners. Every LLP shall ensure that decisions taken by it are recorded in the minutes within 30 days of taking such decisions, and are kept and maintained at the registered office of the LLP. Each partner shall render true accounts and full information of all things affecting the LLP to any partner or his legal representative. If any partner without the consent of the LLP carries on any business of the same nature as and competing with the LLP, he must account for and pay over to the LLP all profits made by him in that business. Every partner shall account to the LLP for any benefit derived by him without the consent of the LLP. ठीक है. No majority of the partners, ये भी important है. Expulsion of partner. So no majority of the partners can expel any partner unless a power to do so has been conferred by express agreement between the partners. ठीक है. बोलता है नो मेजॉरिटी ऑफ पार्टनर्स कैन एक्सपेल एनी पार्टनर. आपको एलएलपी एग्रीमेंट में देना पड़ेगा एक्सपेल्शन के बारे में, अदरवाइज आप एक्सपेल नहीं कर सकते. एंड ऑल डिस्प्यूट्स, ये भी बहुत इंपॉर्टेंट है कि आप कोर्ट में नहीं जा सकते. ऑल डिस्प्यूट विद इन द पार्टनर्स, कई बार सवाल पूछ लेता है. ऑल डिस्प्यूट, तो कम से कम इस शेड्यूल को तो आपको सारे शेड्यूल जो है ये ध्यान से पढ़ लेने हैं. All disputes between the partners arising out of the LLP which cannot be resolved in terms of such agreement shall be referred for arbitration as per the provisions of Arbitration and Conciliation Act. ठीक है, ये हो गया हमारा फर्स्ट शेड्यूल. अब सेकंड शेड्यूल. सेकंड शेड्यूल क्या बोलता है? सेकंड, थर्ड और फोर्थ तीनों शेड्यूल ये कन्वर्जन की बात करते हैं. पहला क्या है? आप क्या कर रहे हो? फर्म को कन्वर्ट कर रहे हो एलएलपी में. ठीक है. So firm is a firm as defined in section 4 of the Indian Partnership Act, and convert in relation to a firm. Converting into LLP means a transfer of the property, assets, interests, rights, privileges, obligations and undertakings of the firm to the LLP. ठीक है. तो एलिजिबिलिटी, क्या एलिजिबिलिटी है? A firm may apply to convert into LLP in accordance with this schedule if and only if the partners of the LLP into which the firm is to be converted comprise all partners of the firm and no one else. जैसे फर्म में 4 पार्टनर हैं तो चारों के चारों पार्टनर एलएलपी में आएंगे. ये भी नहीं हो सकता कि 3 आ जाए, ये भी नहीं हो सकता कि कोई 5वां आ जाए. ठीक है. ऑल द पार्टनर्स ऑफ द फर्म एंड नो वन एल्स, ये बहुत इंपॉर्टेंट है. आपने फर्म को कन्वर्ट करना है एलएलपी में, 4 पार्टनर, चारों के चारों पार्टनर इसमें आएंगे. ठीक है. और 5वां भी नहीं कोई आ सकता. स्टेटमेंट्स टू बी फाइल्ड, क्या स्टेटमेंट फाइल करनी है? स्टेटमेंट बाय ऑल ऑफ इट्स पार्टनर्स इन सच फॉर्म एंड मैनर एंड अकाउंटेड बाय सच फीस एज द सेंट्रल गवर्नमेंट में प्रेस्क्राइब. ठीक है. नेम एंड रजिस्ट्रेशन नंबर इफ एप्लीकेबल ऑफ द फर्म and the date on which the firm was registered under the Indian Partnership Act or under any other law, and incorporation document and statement referred to in section 11. Registration of conversion. ठीक है. तो रजिस्ट्रार विल रजिस्टर. The LLP shall within 15 days of the date of registration inform the concerned registrar of firms with which it was registered. ठीक है कि भाई अब हम कन्वर्ट हो गए एलएलपी में, वो रजिस्ट्रार ऑफ फॉर्म्स को भी इंफॉर्मेशन दे विद इन 15 डेज ऑफ द डेट ऑफ रजिस्ट्रेशन। रजिस्ट्रार में रिफ्यूज टू रजिस्टर, और अपील आपको क्या करनी है, ट्राइब्यूनल को अपील करनी है। इफेक्ट ऑफ रजिस्ट्रेशन, तो एलएलपी आ जाएगी और जो भी टेंजिबल इंटेंजिबल सारे प्रॉपर्टी जो है ये यहां पर आ जाएगी। पेंडिंग प्रोसीडिंग्स का क्या होगा, पहले तो प्रॉपर्टी अगर कोई फर्म के नाम में है उसका क्या होगा। इफ एनी प्रॉपर्टी टू विच सब पैराग्राफ बी ऑफ paragraph 7 applies is registered with any authority, the LLP shall, as soon as practicable after the date of registration, take all necessary steps as required by the relevant authority to notify the authority of the conversion and of the particulars of the LLP in such medium and form as the authority may specify. Pending proceedings. Pending proceedings may be continued, completed and enforced by or against the LLP. कंटिन्यूएशन ऑफ कन्विक्शन, रूलिंग ऑर्डर वगैरह ये सारी चीजें इसमें दे रखे हैं, आप देख लीजिएगा, इसको खास बात नहीं है। चलिए, पार्टनर्स लायबल फॉर लायबिलिटीज एंड ऑब्लिगेशंस ऑफ फर्म बिफोर कन्वर्जन। अच्छा, नोटिस ऑफ कन्वर्जन एंड कॉरेस्पॉन्डेंस, ये इंपॉर्टेंट है। ये क्या कहता है, द एलएलपी शैल एंश्योर दैट फॉर ए पीरियड ऑफ 12 months commencing not later than 14 days after the date of registration, every official correspondence of the LLP bears the following statement that it was, as from the date of registration, converted from firm into LLP, and the name and registration number, if applicable, of the firm from which it was converted। ठीक है, और अगर कोई कंट्रावेंशन है तो उस केस में फाइन है नॉट लेस देन 10,000 रुपीज बट विच में एक्सटेंड टू 1 लाख रुपीज, और फर्दर फाइन है विच शैल नॉट बी लेस देन 50 रुपीज बट विच में एक्सटेंड टू 500 रुपीज फॉर एवरी डे आफ्टर द फर्स्ट डे आफ्टर विच द डिफॉल्ट कंटिन्यू। अब आ जाता है कन्वर्जन फ्रॉम प्राइवेट कंपनी इनटू एलएलपी। एलिजिबिलिटी, एलिजिबिलिटी बहुत इंपॉर्टेंट है इसमें। वो क्या कहता है, ए कंपनी में अप्लाई टू कन्वर्ट इनटू एलएलपी इफ एंड ओनली इफ, पहला, देयर इज नो सिक्योरिटी इंटरेस्ट इन इट्स एसेट्स सबसिस्टिंग और इन फोर्स एट द टाइम ऑफ एप्लीकेशन। अगर आपने कोई सिक्योरिटी इंटरेस्ट क्रिएट किया हुआ है तो फिर उस केस में यू विल नॉट बी एलिजिबल टू कन्वर्ट द कंपनी इनटू एलएलपी। ठीक है, द पार्टनर्स ऑफ द एलएलपी टू विच इट कन्वर्ट्स कंप्राइज ऑल द शेयर होल्डर्स ऑफ द कंपनी एंड नो वन एल्स। तो सारे के सारे शेयर होल्डर इसमें आएंगे और कोई नया नहीं आएगा। अपॉन सच कन्वर्जन, द कंपनी, its shareholders, the LLP to which the company has converted and the partners of the LLP shall be bound by the provisions of this schedule. Statement फाइल करनी है, statement by all its shareholders, और वही 15 डेज में आपको आरओसी को इन्फॉर्म कर। प्रॉपर्टी का क्या होगा, प्रॉपर्टी में आपको जिसके पास भी प्रॉपर्टी रजिस्टर उसको इन्फॉर्म करना। पेंडिंग प्रोसीडिंग्स एलएलपी के केस में चल सकती है, बाकी सारी चीजें सेम ही है। नोटिस ऑफ कन्वर्जन भी आपको देना है 12 महीने तक। उसके बाद आ जाता है जो अनलिस्टेड पब्लिक कंपनी है, इसको आपने एलएलपी में कन्वर्ट करना है। तो क्या क्या क्लॉसेस, ऑलमोस्ट सारे एक जैसे ही है। पहला, कोई सिक्योरिटी इंटरेस्ट सबसिस्टिंग नहीं है, और जो पार्टनर्स ऑफ द एलएलपी है टू विच इट कन्वर्ट्स कंप्राइज ऑल द शेयर होल्डर्स ऑफ द कंपनी एंड नो वन एल्स। सारे शेयर होल्डर्स को एक स्टेटमेंट फाइल करनी है, नेम एंड रजिस्ट्रेशन नंबर ऑफ द कंपनी, डेट, इनकॉर्पोरेशन डॉक्यूमेंट। प्रॉपर्टी के बारे में आपको जो रजिस्ट्रार है, रेलेवेंट अथॉरिटी, उनको बताना है। पेंडिंग प्रोसीडिंग्स कंटिन्यू रहेंगी, ये सब चीजें सेम है। उसके बाद ये थोड़ा सा देख लेते हैं, रिसेंट अपडेट्स क्या है। एक तो सी पेस इंक्लूजन, ये एलएलपी अमेंडमेंट रूल्स 2024 इंट्रोड्यूस द सेंटर फॉर प्रोसेसिंग एक्सेलरेटेड कॉर्पोरेट एग्जिट, सी पेस। ठीक है। So Rule 37 was amended to allow LLP to file for striking off closure through CPAs instead of just the regional registrar. So this has significantly speeded up the voluntary winding up process. उसके बाद में significant beneficial ownership rules. Under the LLP SBO rules 2023, LLPs are now required to identify individuals who hold a significant beneficial interest, usually 10% or more, and file form LLP Band 2. Then resident partner requirement relaxed. The 2021 amendment permanently changed the residency rules. ठीक है। A resident in India now means a person who stayed in India for at least 120 days. पहले 182 days होता था ड्यूरिंग द फाइनेंशियल ईयर। अच्छा, एक स्मॉल एलएलपी स्टेटस जिसपे ऑडिट जरूरी नहीं है। ऑडिट कब जरूरी है? इफ योर कंट्रीब्यूशन एक्सीड्स 25 lakhs और इफ योर टर्नओवर एक्सीड्स 40 lakhs। ठीक है। बट इफ योर कंट्रीब्यूशन इज लेस देन 20 lakhs, 25 lakhs एंड टर्नओवर इज लेस देन 40 lakhs, देन स्मॉल एलएलपी स्टेटस है, तो ऑडिट कराना जरूरी नहीं है। एनुअल फाइलिंग, फॉर्म नंबर 11 है एनुअल रिटर्न के लिए, और फॉर्म 8 है स्टेटमेंट ऑफ अकाउंट्स के लिए। पेनल्टीज है, नाउ फॉलो स्मॉल एलएलपी वर्सेस अदर्स फी स्ट्रक्चर, सो स्मॉल एलएलपी पे सिग्निफिकेंटली लेस फॉर डिलेज। फिर वेब बेस्ड फाइलिंग है, ऑल फाइलिंग्स मस्ट बी डन ऑन द एमसीए V3 पोर्टल यूजिंग ए डीएससी। अच्छा, तो चलो ये तो कुछ हुआ इसके बारे में। और देख लेते हैं, एक तो अभी तो बहुत टाइम है अपने पास। ये तो कंपनी से ऊपर इसमें नहीं, वन भी है इसमें। हाँ। ये तो कंपनी से होना चाहता है इसमें। एक मिनट, ये देख लेता हूँ। ये जस्ट मिनट, एक मिनट मेरे को दे दीजिए। फॉरेन एलएलपी, एक इशू इसमें आता है, जस्ट मिनट शेयर करता हूँ। वन इशू विच कम्स is whether an Indian LLP can merge with Indian company. इसमें यह है कि if an Indian LLP is proposed to be merged into an Indian company, then firstly the LLP has to apply for registration under section 366 of the Companies Act. ठीक है, फॉरेन LLP के लिए रिक्वायरमेंट नहीं है. If there is a foreign company, if there is a foreign LLP and it wants to merge with an Indian company, they can direct merger is allowed. But if there is an Indian company and if there is an Indian LLP and it wants to merge itself with an Indian company, then the LLP will first have to convert itself into Indian company and only then merger will be allowed. But if there is a foreign LLP and it wants to convert, it wants to merge itself with an Indian company, then direct merger is allowed. This is the fact. ये है basically. So in this case, what were the facts? The transferor LLP was incorporated under the provisions of LLP Act, having its registered office in Chennai. So it was an Indian LLP. And the transferee company is a private limited company under the Companies Act. So both the incorporated bodies are engaged in the business of establishing and or acquiring similar business. ठीक है. So NCLT, after considering the scheme, found that all the statutory compliances have been made. Section 232, 232. NCLT further found that as per section 394(4)(b) of the Companies Act, LLP can be merged into company. But there is no such provision in the Companies Act. However, explanation to subsection 2 of section 234 of the Companies Act permits a foreign LLP to merge with an Indian company. Then it would be wrong to presume that the Companies Act prohibits of a merger of an Indian LLP with an Indian company. So this is what NCLT felt. Thus, there does not appear any express legal bar to allow merger of an Indian LLP with an Indian company. Therefore, NCLT, applying the principle of casus omissus by the impugned order, allowed the amalgamation of transferor LLP with the transferee company. Now, being aggrieved, the appellants have filed the present appeal. Then, what was the decision of the NCLT? NCLT observed that the provisions of the Companies Act as a whole, in reference of conversion of Indian LLP into Indian company, there is no ambiguity or absurdity or anomalous results which could not have been intended by the legislature. The principle of casus omissus cannot be supplied by the court except in the case of clear necessity. The legislature has enacted a provision in the Companies Act for conversion of Indian LLP into Indian company and vice versa in the LLP Act. Thus, there is no question of infringement of any constitutional right of the respondent. The NCLT held that the order of NCLT is not sustainable in law and thus set aside, which is allowing the merger of an Indian LLP with an Indian company without such registration. So they say Indian LLP with Indian company not allowed directly. So first convert the Indian LLP into Indian company and then allow merger. But foreign LLP, Indian company, direct merger allowed. This is the gist. And they sometimes ask question on this. Just a minute. Just a minute. Case study on bailment to contact. चलो वैसे डिस्कस कर लेते हैं, यहाँ पर तो है नहीं। Okay. Now let us see some of the provisions regarding this Partnership Act. उसके बाद में फिर कॉन्ट्रैक्ट एक्ट और सेल ऑफ गुड्स कर लेंगे जल्दी से। पार्टनरशिप एक्ट, पार्टनरशिप एक्ट में लेट अस सी सम ऑफ द इंपॉर्टेंट प्रोविजंस। कुछ तो पता ही है आपको, मेन बात है। नाउ लेट अस सी द प्रोविजंस रिगार्डिंग, ये शेयर हो रही नहीं हो रही? आई होप नाउ इट इज विजिबल। इज इट विजिबल?
Yes.
हाँ
Yes.
हाँ। एडमिशन ऑफ पार्टनर, consent of all the partners is required, and liability of new partner, it starts from the date he has been admitted unless he agrees for past liability with consent of the creditor. If A and B were old partner and C was admitted with past liabilities, then also creditor cannot demand from C. Creditor can demand only from A and B, and in turn they can ask from C. Okay? Now regarding partner, retirement of partner. Partner can retire by consent of all partners, express in agreement or notice to other partner if partnership is at will. Retiring partner does not get discharged from the old liability unless continuing partners agree with the creditor and new reconstituted firm execute contract with creditors. Till public notice is given, he continues to be liable. Taken. And suppose somebody deals with the firm and he was not aware that retiring partner was firm, then in such case retiring partner is not liable. And notice can be given either by the retiring partner or by continuing partners. Expulsion of partner. This is very important, and sometimes they form a case study on this. Expulsion provision must be mentioned in the agreement. Consent of majority of the partners is required. It should be done in good faith. Expulsion must be in the interest of the firm. He should be given notice for expulsion. Opportunity of being heard must be given, else expulsion is null and void. And it is not dissolution of firm, and firm can continue if it is at will. So sometimes they frame a case study like there are three partners. They went to a club and they're along with their wives, and their wives quarreled. So two of the partners, they expelled the third partner. So in this case, whether expulsion is valid, the answer is no, because it was not done in good faith, right? And it did not have any business connection. So expulsion must be in the interest of the firm. It should be done in good faith. It should be given opportunity also. It should be given notice for expulsion. These all are important. Insolvency of partner. So if a partner becomes insolvent, then he cannot continue as partner and he ceases to be a partner from the date of the order. And his estate is not liable for any act done by the firm after the date of the order. Firm is also not liable for any act done by him after the date of the order. And if rest of the partner agree to continue firm, they can continue. Now regarding death of partner, in general, firm gets dissolved on death of any partner. If in agreement it is provided that firm can continue, right? So then it can continue also but minimum number of partners should not go below 2. And in case of death, no public notice is required to be given. This is also important. Minor partner. We all know that partner can be admitted only to the benefits of the partnership. So during the age of on minority, he can be admitted only for profits, not for losses. He is entitled for profit and property. He has got right to access to books of account. He is not personally liable, but his profit and property in the firm is liable. He can file suit against firm for profit and property, but not vice versa. Okay. Now, he has got discretion after attaining the age of majority. So public notice should be given by him within 6 months, and if he fails, then he is automatically treated as continuing partner. And if he accepts to continue as partner, he will share same position as other partners. He will be personally liable from the date when he was admitted to the benefits of partnership, and share of property and profit will be the same as before. If he does not accept or he doesn't wish to continue as a partner, then liability is same as before. He is not liable for any further liabilities, and he can take his share of profit and property. Otherwise, if they do not pay him, then he can sue the partners. Dissolution of firm. Registration of firm. Consequences of non-registration. So if your partnership firm is not registered, then partner or firm cannot file civil suit against third party, and no relief to partner for set off of claim. Maximum is 100. Aggrieved partner cannot take legal action against other partner of the firm, but third party can sue the firm or partners. These are some rules which are applicable in the absence of partnership deed. So suppose there is no partnership deed, then profit sharing ratio equal, interest on capital no. Okay. Even if there is a provision in the partnership deed to pay interest on capital, it is paid only when there is a profit. Okay. So interest on capital is never paid if the firm is incurring loss, even though it is permissible in the partnership deed. If the profit is inadequate to pay interest on capital, it will be paid to the extent of profit in the ratio of interest due to partners. Interest on drawings, no interest is charged on drawings of partners. Interest on partners loan, interest is paid at the rate of 6% per annum, even if there is a loss. Salary commission to partner, no salary or commission is paid for the conduct of business to any partner. Admission of a partner, no new partner can be admitted without the consent of the existing partners, and a minor can be admitted with the consent of all the existing partners. This we can see, this case study we can see. It's a very small case study. So it says a deed of partnership was executed between Mr. Ram and Mr. Shyam, wherein both agreed to carry on business in partnership on the terms and conditions as recorded in the partnership deed. Each partner will be entitled to a share in the goodwill of the firm according to his share in the partnership. If any partner wishes to retire from the firm, he can do so by giving notice in writing to the other partners of his intention to retire after completion of the pending construction works, and the retirement shall take, and the amount due at the foot of the accounts is paid or received by him, as the case may be. The partnership firm obtained a contract for the construction of building on Mahatma Gandhi Road, New Delhi from Messrs. MB Construction. But before the completion of the contract, one of the partners, he gave a notice for dissolution of the firm. So first question is, how can a partnership firm be dissolved? Second is, among the following, what are the not prescribed modes of dissolution? So these are the 4 questions, and answers also I have given. You can have a look at the answers. ये पार्टनरशिप फॉर्म का एक्ट है। इतना ज्यादा डिटेल में जरूरत नहीं, बस आप थोड़ा एक्सपल्शन ऑफ पार्टनर, डिसोल्यूशन ऑफ पार्टनर भी देख लेंगे तो हो जाएगा। हाँ, एक और देख लेते हैं। सेल ऑफ गुड्स। इन केस ऑफ सेल ऑफ गुड्स, एक जो केस स्टडी आजकल आ रही है, वो केस स्टडी क्या है? व्हाट इज दैट केस स्टडी? देर आर टू पर्सन्स, ए एंड बी। A is thinking of selling his car. ठीक है। Now B approaches him and he says that, okay, I have heard that you want to sell your car. So what is the price? So A says, I want to sell my car for 1 lakh rupees. ठीक है। Now B pays him an advance of 20,000 rupees. ठीक है। And there is an agreement that, okay, B will come within 1 month and pay the balance and take the delivery of the car. है ना? He has already inspected the car. Now, instead of 1 month, 1 year lapses. But still, there is no trace of B. Even A tries to call him, but B is unreachable. After 1 year, B suddenly appears on the scene and asks A regarding the delivery of the car. In the meantime, the car has met with an accident. So now they frame certain questions based on this case study. Number one, now B is also unwilling to some extent that he, because the car has met with a major accident, but he says that you give me refund of my 20,000. Now first question is whether he can ask for this refund, because the agreement was for 1 month only and for 1 year he was untraceable. Now suddenly out of the wind he has appeared. So whether he can ask for a refund of his advance, this is first question. Second is, who will be responsible for the loss caused to the car? So the answer which is coming is that B cannot ask for a refund of the advance, because even if time is not stipulated, although in this case that there was a mention of the time also, that he will take the delivery within 1 month, but had he appeared after say 1 month and 2-3 days, then of course he was entitled for the advance, but not after 1 year, because now more than sufficient time has elapsed. And even if time is not the essence of the contract, so there is a common perception that okay, one should act within a reasonable time. Second is because the property has not yet passed to B, so A will be responsible for the loss caused. Just okay. और काजल जी, आपके पास कोई मटेरियल है क्या इसका, अलाइड लॉज वाला?
सर आपने भेजा तो था पूरा लाइट लॉस का।
हाँ 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 हाँ। नहीं, और कोई पर्टिकुलर क्वेश्चन आपके माइंड में आ रहा है अलाइड लॉज से रिलेटेड जो हम डिस्कस कर सकते हैं, पर्टिकुलर क्वेश्चन कोई, या कोई
सर
पर्टिकुलर टॉपिक?
अभी तो नहीं है सर, मैं पढ़ लूंगी तो हो सकता है फिर कुछ
ओके ओके।
क्वेश्चन कर
नरेंद्र
लूँ।
जी?
नो सर, नो सर, नो।
ओके।
मोर देन इनफ मटेरियल सर।
हम्म। हम्म। तो आज की कथा यही समाप्त करते हैं, है ना? फिर
यस
नेक्स्ट
सर।
टाइम करते हैं, हाँ ठीक है। तो एक बार पढ़ लीजिए, यू प्लीज गो थ्रू द मटेरियल।
यस सर।
और इसका आई थिंक वीडियो लेक्चर्स आर आल्सो विद यू। वीडियो लेक्चर है आपके पास या नहीं?
किसके